Denzel Washington stood tall at the lectern in Courtroom 3 of the United States Supreme Court. His crisply pressed navy suit contrasted starkly with the austere marble columns rising behind him. Moments before, Chief Justice John Roberts had broken tradition by interrupting Washington's opening argument with a tart and personal comment. "Mr. Washington, I find it hard to believe that someone from your background truly comprehends the constitutional ramifications of your stance." A wave of tension swept through the crowded chamber. Law clerks exchanged alarmed glances. Seasoned attorneys sat straighter in their seats. Journalists scrambled to record the moment. But Washington, preeminent actor and, as few yet knew, recently minted lawyer, flinched not. Even though he was most famous for his domineering presence on screen, this was no act. For 5 years, he had kept his legal studies hidden, obtaining a degree from Howard University during filming breaks. Now, with 9 justices and scores of onlookers observing, he was ready to transform a questioning grilling into the greatest oral argument in recent history. This was not just another hearing. It was a moment of destiny. Washington had arrived to demonstrate that legal genius can arise from anywhere and possibly redefine the understanding of the Constitution along the way. Prior to delving into the historic legal showdown, viewers were reminded to like and subscribe for more stories that celebrate preparation, perseverance, and opportunity. The case had been on the national radar since Washington's name hit the docket. 3 months prior, he had submitted an amicus curiae brief in Henderson v. Department of Justice, a case dealing with civil forfeiture statutes that targeted minority communities disproportionately. At first scoffed at as a celebrity gimmick, not many in the legal community knew that Washington had indeed earned his J.D., learning quietly and independently at Howard Law. His contribution wasn't an act. It was the result of years of devotion. Chief Justice Roberts, aged 67, presided over the court with the mature gravitas of a man who had clerked for Chief Justice Rehnquist, worked as Principal Deputy Solicitor General, and sat on the bench for almost 20 years. Famously known for his piercing hypotheticals and wicked sense of humor, Roberts had built a reputation for eviscerating poorly prepared attorneys with clinical precision. So when Washington was surprised with 10 minutes of oral argument on behalf of the petitioner, a novelty for one simply submitting an amicus brief, everybody in the legal community was abuzz. Most assumed the court was trying to make itself more relatable with a celebrity cameo. But those who had actually taken the trouble to read Washington's 40-page brief saw something the cynics hadn't: a new, historically based argument about the Fifth Amendment's takings clause that challenged settled precedent. This isn't Hollywood. You can't simply memorize words and hope to sway the Supreme Court, someone who works as a corporate attorney murmured from the gallery. But this was not Hollywood, and Washington was not pretending. High were the stakes. The case of Henderson was focused on the seizure by the government of a community center and adjacent properties within a majority-black Philadelphia neighborhood. The rationale? A single narcotics transaction had been completed on an open sidewalk adjacent. No criminals were prosecuted, but millions of dollars worth of property was seized through civil forfeiture. If Washington prevailed, it would have the potential to severely limit the government's power to seize property without criminal conviction. If he lost, his carefully developed theories could be relegated to the category of naive hopes of a well-intentioned celebrity. As Washington moved forward, the courtroom fell silent. Unlike most first-time attorneys, he moved with quiet confidence, the poise of someone accustomed to commanding high-stakes situations. Yet few anticipated the level of preparation he would show. "Mr. Chief Justice, and may it please the court," he started, his deep voice carrying without a microphone. "The Fifth Amendment's clause that private property shall not be taken for public use without just compensation was originally understood to require not just monetary compensation, but also a valid public purpose and minimal procedural safeguards before government authority could be exercised to dispossess a citizen." The introduction had been calm and courteous, but Roberts, never one to give in without questioning, interjected less than a minute after that. "Mr. Washington," he remarked, his voice tinged with incredulity, "as I value your concern for this case, I struggle to see how someone from your background truly grasps the constitutional ramifications of your stance. Your brief appears to disregard 200 years of established precedent regarding civil forfeiture. Gasps and mutters trailed the unusually sharp taunt. Justice Sotomayor changed position in her chair. Justice Kagan's face clouded. Washington paused, looked across at Roberts, and responded in measured authority. "Chief Justice Roberts," he stated, "I think my argument comports with the original understanding of the Fifth Amendment, as Justice Thomas articulated in his concurrence in Timms v. Indiana. But if the court will, let us read the original text and context jointly." He pulled open a dog-eared copy of the Constitution and some founding documents, items that few advocates ever placed on the podium. His preparation was unmistakable. Roberts attempted again with a more technical question. "Your brief indicates civil forfeiture was historically confined to admiralty and customs law. But what about the Palmyra? In 1827, this court acknowledged broader forfeiture authority, a trap that many lawyers had fallen into. Washington did not. With respect, Chief Justice, I spoke about the Palmyra in full detail. Page 23 of my brief," he said, turning to the page without hesitation. It was a case at sea that dealt with piracy, where Justice Story noted that the ship itself was treated as the perpetrator. That legal fiction was reasonable when the court couldn't find personal jurisdiction, but it was never intended to be used to authorize modern land-based forfeitures against American citizens who have full due process rights. He waited before pounding the point home. "I've read each civil forfeiture case between 1789 and 1850, the total of which stands at 27. Every one of them included customs abuses, maritime infractions, or piracy. None endorsed the sort of real property confiscations found in Henderson." The courtroom was quieter now. He was not only defending, he was teaching. Justice Alito chimed in next. "Interesting historical insight, Mr. Washington. But what of our more recent precedent? In Brilliance v. Michigan, we upheld the forfeiture of a car belonging to an innocent spouse." Washington didn't hesitate. "Justice Alito, with all due respect, I believe Brilliance was wrongly decided," he said, drawing audible response from the gallery. "And I'm not alone. Justices Thomas and Ginsburg, despite differing ideology, dissented strenuously. In addition, Brilliance created a tension that the court has since resolved." He cited Austin v. United States and Timms v. Indiana, instances in which the court held that civil forfeiture should be mindful of the excessive fines clause and other constitutional constraints. Those rulings recognize civil forfeiture is quasi-criminal and must adhere to constitutional protections. The momentum was changing. Even the most reserved justices were leaning forward. Clarence Thomas, who was famous for his silence during oral arguments, listened intently. Justice Kavanaugh expressed a pragmatic question. "Mr. Washington, your historical case is compelling, but civil forfeiture is an important law enforcement tool. Are you suggesting that we eliminate it outright?" "Not at all, Justice Kavanaugh," Washington responded. "I suggest bringing it back to its constitutional roots, confined to admiralty, customs, or where the government can't get personal jurisdiction. But when prosecutors can bring charges and don't, but still take property, due process and the takings clause require more." Roberts, now distinctly impressed but still questioning, switched direction. "You've used a number of obscure early state cases. How do we know they represent the mainstream legal conception of the period?" This was the opportunity Washington had drilled for. "I'm glad you brought that up," he added with a half-smile. "Those cases aren't exceptions. They are symptoms of a uniform national trend." He proceeded to recite from memory the factual particulars of 8 state Supreme Court rulings, showing how together they cumulatively supported a tight, originalist interpretation of civil forfeiture. Justice Kagan, apparently fascinated, asked, "Mr. Washington, your work in history is impressive. Did you work with legal historians?" "For the most part, no," he replied with a hint of pride. "I read scholarly commentary, but the archival research, finding, reading, and analyzing the original documents, I did myself. It was part of my coursework at Howard Law, and I've continued that research ever since." Gasps and murmurs returned. Many in the room were hearing for the first time that Washington's legal education was not a vanity project. It was deeply serious. Justice Sotomayor leaned in. Let's go back to the facts. How would your argument be applicable to the Henderson property? Washington replied in a resolute tone. Justice Sotomayor, the taking fails on several grounds. First, the charged criminal offense was perpetrated by a third party on an open sidewalk. Second, no facts link the owners of the property to the crime. Third, the taking by the government was grossly out of proportion to any injury. He paused, and maybe most significantly, the seizure fails to satisfy the public use requirement. Appropriating private property and putting it into the general fund of the government, without some special benefit to the public, violates the original meaning of the takings clause. As he went on, court officers subtly prolonged his time of argument, a relatively uncommon but revealing move. The justices were all in. Chief Justice Roberts, who had begun the hearing questioning the credibility of Washington, now realized the truth. Anything but an amateur, Washington had presented one of the most serious arguments anyone could remember. What started as a disrespectful challenge had become a profound rethinking of constitutional law. And Washington was only beginning. Roberts, I have indeed considered the practical implications carefully, Washington said as he produced a document containing detailed statistics. I've analyzed data from the Department of Justice's asset forfeiture program over the past decade. Approximately 87% of current forfeitures would remain untouched under my proposed framework. Those involving unclaimed property, customs violations, and cases with criminal convictions. He turned a page in his notes. The only forfeitures that would be impacted are those that most offend our constitutional traditions. Seizures from innocent owners on the basis of weak connections to suspected wrongdoing, often without any criminal charges being brought. These represent less than 13% of forfeitures by value, but they cause disproportionate damage to communities, including the one in Philadelphia impacted by this case. Justice Amy Coney Barrett, who had been paying close attention, interrupted. Mr. Washington, your brief presents an interesting textual argument concerning the interrelationship between the Due Process Clause and the Takings Clause, one I don't think any scholar has ever before considered. Could you say more? Her query evidenced sincere intellectual curiosity, indicating that Washington's reasoning was resonating at the level of the highest judiciary. Washington nodded. Justice Barrett, thank you for that question. Although these clauses normally are examined in isolation, historical evidence indicates the founders regarded property protections as a single concept. When the government takes property from citizens without substantial procedural protections, both clauses are implicated. He picked up steam as he went. James Madison, who wrote both protections, often stressed the connection between procedural fairness and property rights. In a letter to Jefferson in 1788, he directly linked arbitrary seizures to violations of due process and uncompensated takings. Washington pulled out a photocopy of a handwritten letter. I visited the Madison papers at the Library of Congress in preparation for this argument. This letter hasn't been cited in prior forfeiture cases, but Madison clearly wrote that seizing a citizen's land without proper process or public purpose constitutes a double violence against the most sacred rights in an ordered society. Justice Clarence Thomas, quiet until now, but obviously listening, finally broke his silence. The unusual action caused reporters to lean forward. Mr. Washington, your originalist methodology is refreshing. You've persuasively demonstrated that contemporary civil forfeiture far exceeds historical boundaries. But tell me, how would you differentiate this case from Bennis? Would you have us overrule that precedent? The question aimed at the doctrine of stare decisis, the court's conservative approach to overruling precedent. Washington replied with accuracy. Justice Thomas, although I think Bennis was wrongly decided, this court does not necessarily have to affirmatively overrule it to decide for the petitioners in Henderson. Bennis was a case involving a car used immediately in criminal activity, in accord with early forfeiture doctrine. Henderson, on the other hand, concerns real estate with the weakest of ties to a crime. The court can make the two cases distinct, explaining that civil forfeiture has to comply with historical practice and constitutional constraints. This well-crafted reply demonstrated Washington's profound appreciation for the court's institutional priorities. He was not merely presenting theoretical legal concepts. He was demonstrating to the justices a way out that respected precedent but moved constitutional ideals forward. Chief Justice Roberts set aside Washington's pedigree and set to the task of merits, asked one final question. Mr. Washington, assuming we bought your framework, what precise test would you have us use to analyze civil forfeitures in the future? This sort of question is usually reserved for the very best advocates, a charge to assist in formulating doctrine, not simply presenting a case. The overflowing courtroom recognized the gravity of the moment. With no hesitation, Washington responded. Chief Justice Roberts set aside Washington's pedigree and set to the task of merits, asked one final question. Mr. Washington, assuming we bought your framework, what precise test would you have us use to analyze civil forfeitures in the future? This sort of question is usually reserved for the very best advocates, a charge to assist in formulating doctrine, not simply presenting a case. The overflowing courtroom recognized the gravity of the moment. With no hesitation, Washington responded. Chief Justice, I would suggest a three-part test based on the original meaning and consistent with this court's decisions in Austin and Timms. Holding up 3 fingers, he enumerated the components. First, the government has to make a sufficient nexus between the property and criminal activity, not the weak connection offered here. Second, if the owner is subject to the court's jurisdiction, due process requires a criminal conviction or clear and convincing evidence that the owner knowingly agreed to the illegal use. Third, the forfeiture has to meet the public use requirement by remedying a particular harm, not merely raising revenue. He concluded firmly, but with a calm. This approach respects the Constitution, has a historical precedent, provides guidance for lower courts, and shields innocent Americans from one of the most extreme exercises of governmental power, the taking of their homes, businesses, and community institutions without meaningful process. When Washington's time ran out, the courtroom was silent. No one spoke up with the customary, "Your time has expired." Instead, a few justices kept taking notes, while some others leaned back, looking introspective. Then Chief Justice Roberts spoke at last. His voice was different. Thank you, Mr. Washington. Your argument has been exceptionally informative. That benign comment passed on a stronger message. His initial try to brush Washington aside had boomeranged, exposing a serious legal mind instead. As Washington sat back down, the attorney for the government stood up, clearly shaken. The tone in the courtroom had changed. What had started as a routine defense of governmental power had become a constitutional struggle up a hill, and one that now seemed certain to fail. Legal reporters quickly knew they were seeing something historic. Washington's argument could redefine civil forfeiture doctrine and redefine who is regarded as a legitimate advocate at the pinnacle of American law. Soon to be known as the Washington argument, the encounter sent shockwaves through legal and cultural communities. Law professors soon added the transcript to their curricula. Scholars across the political divide were amazed and impressed at the richness and innovativeness of Washington's argumentation. CNN's Jeffrey Toobin summed it up best. I've covered the Supreme Court for more than 20 years and have never seen anything like this. Denzel Washington didn't just match the Chief Justice. He delivered what may be the strongest originalist critique of civil forfeiture ever presented to the court. The following morning, Twitter trending included hashtags #LegalScholarDenzel and #DenzelTeachesTheChief. Clips of Washington reciting Madison and referencing precedent case law from memory from earlier in his career began to go viral, with millions of views. A younger generation, grown up on his performances, now viewed him differently. 3 days afterward, the New York Times ran a profile revealing Washington's legal history. It told how he graduated from Howard University School of Law with highest honors, attending law school at night while still pursuing an acting career. Professors said that he was particularly dedicated and passionately interested in constitutional history and civil rights. He never asked for preferential treatment, said Professor Marcus Johnson. Most of the students didn't even know who he was for weeks. He was merely one more student, albeit a student with a powerful voice and uncommon concentration. The article further uncovered that Washington had privately funded scholarships for underrepresented students, refusing to have his name associated with them. His legal aspirations were not ego-driven, but rather motivated by a long-standing passion for justice reform and the need to contribute meaningfully. Legal blogs and podcasts dissected every aspect of the argument. Much was made about how suddenly Chief Justice Roberts' tone had changed, from contemptuous to profoundly respectful, as Washington proved mastery of constitutional law. He was no longer an advocacy celebrity. He was now a peer. What we saw was a live correction of assumptions, NPR's Nina Totenberg said. The Chief Justice anticipated a dilettante. He received a legal scholar. That change in 50 minutes says a lot about perception in our line of work. The wider legal community sat up. Washington was invited to give the keynote speech at the American Bar Association's national conference. Applications to law schools from underrepresented groups increased by 34% and cited Washington as the inspiration behind many of those applications. Washington was characteristically modest. Asked about the argument at a movie premiere, he merely said, "The law, like acting, rewards preparation. I'm grateful the court allowed me to present a constitutional argument that I hope advances justice." 6 weeks after, the Supreme Court delivered its ruling in Henderson v. Department of Justice. In a 7-2 decision, the court ruled in favor of the petitioners, significantly curtailing civil forfeiture authority along lines generally similar to Washington's proposal. Roberts wrote the majority opinion, broadly interpreted as an act of humility and concession. After examining the record of history and the Constitution, Roberts wrote, "We hold that civil forfeiture has grown beyond constitutional limits. Though it remains a legitimate device in narrow contexts, the government may not take property from innocent owners on slender grounds of alleged criminal activity, especially when such property performs important public purposes." The opinion quoted Washington's oral argument 4 times, taking most of his 3-part test. A footnote commended the amicus counsel for exceptional historical research shedding light on founding-era protections of property. Justice Thomas wrote a concurring opinion calling for a wholesale re-examination of civil forfeiture doctrine. Justice Sotomayor's concurrence highlighted its disproportionate damage to vulnerable communities, drawing on Washington's data. Perhaps most notably, Roberts concluded with a personal remark. "This case reminds us that legal wisdom can come from unexpected places. Our justice system grows stronger when diverse perspectives are heard. We benefited greatly from the advocacy and insight brought to this case." The effect of the ruling was immediate and far-reaching. States altered forfeiture statutes. Millions of dollars in property were restored to innocent owners and community groups. Police departments redirected their attention towards seizure practices supported by criminal convictions. For Washington, this was the start of a new chapter. He established the Washington Justice Initiative, a nonprofit organization advocating for legal advocacy on behalf of communities harmed by forfeiture and loss of property. Law schools nationwide invited him to guest lecture on constitutional history. 6 months afterward, he and Chief Justice Roberts both appeared together at a Georgetown Law Forum on civic education. Their open, civil exchange, tinged with humor about their previous courtroom encounter, showed how processes of adversariness can lead to greater understanding. Roberts openly acknowledged what many had come to understand. "Mr. Washington taught me never to confuse celebrity with capability, nor to dismiss non-traditional legal training. His argument in Henderson will be studied by generations of law students." Washington replied with quiet grace, "The beauty of our legal system is that arguments are judged on their merits, not on the background of the person making them. I'm grateful the court was willing to engage seriously with the issues in Henderson, even if the messenger was unexpected."